Well, I'm relaxed.
You are relaxed?
Yes, CJ.
Okay. But very briefly, educationally, you've worked your way all the way up to a master's degree.
Yes, that's correct.
Why did you think it was necessary to acquire a master's degree?
Well, CJ, at the time, you will see I was still a regional magistrate.
Yes.
I wanted to venture out of the magistracy. I thought firstly that I would become an attorney or go into academia. And my decisions were overtaken by events in that I became one of the leaders of the Judicial Officers Association of South Africa. I then became centrally involved in teaching magistrates on many issues, and also part of the Equality Courts training. And
that you and I attended at the same time.
Yes, when you left something for the police. Yeah, that's correct, CJ. Yeah.
And for how many years have you been a judge now?
Since June 2005, so it's about 11 years.
11 years, and for how many as a judge of the Labour Appeal Court?
That's 3 years.
There, and you're acting at the Constitutional Court now?
Currently, yes, that's correct.
And how did you find that experience?
Quite daunting, CJ, I must say. Firstly, it's a total paradigm shift in that all decisions must be taken by at least 8 judges. So it's a lot of work, especially because most of the communication is done by email. Any time of the day, any time of the night, decisions has to be taken, and you must be ready. In terms of preparation too, writing judgments or post-hearing notes, firstly, you're not only concentrating on your own view and your own judgment, you have to listen attentively to what your colleagues on the bench ask, because that also gives you an indication of the possible direction in which they are thinking. So when you write even your post-hearing note, you must make sure that you accommodate some of the views, if not all of the views, of your colleagues. Unlike when you're sitting in the High Court as a single judge, you just write the judgment and that's it.
I know this is not an interview for a Constitutional Court position, but I wonder whether you were like me before I got to the Constitutional Court, thinking that these people are really having it easy. So these few judgments in a year, what do they do all this time with these long recesses? Were you like that, thinking that you're going to relax a little bit?
No, definitely not, CJ. I think my experience at the Labour Appeal Court level was that, well, you have a lot of reading to do. You have petitions to do. So I expected that, not, I must confess, the same volumes. I mean, the new applications that come in, especially now that the Constitutional Court's jurisdiction is somewhat expanded, not to deal only with constitutional matters, and because it's now the apex court, there are so many new applications for either direct access or where petitions have been refused by the Supreme Court of Appeal. So it's hectic. It's a lot of work.
Well, finally, I only got to know for the first time. I actually didn't know your other name is John. I visited the U.S. Supreme Court earlier this year. I only got to know then of this organization of which you are a vice president. One of the judges told me about you and the crucial role you're playing in that organization worldwide, and the difference that it could make in improving the performance of the courts in South Africa. You want to touch very briefly on this organization of which you are a vice president?
Thank you, Chief Justice. It is a global organization which consists of both magistrates and judges. In some of the countries in Europe, you can in one year be a magistrate or a judge, and the next year a prosecutor. So in some of those jurisdictions,
Like Germany, for instance.
like Germany exactly, and Austria. So in some cases, there are also prosecutors who are involved. I have been involved with this organization since my days in JSC, when I was the president of JSC. And I was then elected as the president of the African Regional Group, and then made the vice president and honorary vice president of the group.
Yes. JP?
Thank you, CJ. Judge Musi, I see that you've been in leadership positions since 2002 when you were the chair of JSC. Is that correct?
That is correct.
And you have served in various positions, president of JSC, board member of the Law, Race and Gender Research Unit, board member of Canada SA Justice Leadership.
Linkage Project.
Leadership Project, yes. Linkage Project. Do you think that those leadership positions that you have previously occupied could stand you in good stead if you were to be appointed as the Deputy Judge President of the division?
Yes, definitely, JP, because when I function in those organizations, it's organizations consisting mostly of peers. So one gives leadership, one gives direction to colleagues, to your peers. So definitely one therefore learns not only organizational dynamics, but also how to deal and interact with colleagues. And that's it.
You also had occasion to act as the judge president, as the acting judge president of the division for a term. Did you experience any challenges at that stage? You were basically in charge, right, of the division. Were there any challenges that you experienced?
There were challenges, but not challenges that I could not overcome. Because as you know, JP, with the advent of the Superior Courts Act, the JP is no longer only in charge of judges and judicial functions at the court itself. The JP also coordinates all judicial functions within the province. So that inter alia means that not only as JP do you interact with regional magistrates, district magistrates, you also coordinate their work. There are PEEC meetings, that's Provincial Efficiency Enhancement Committee meetings, in order to coordinate the whole province. On the other hand, you have the whole case flow management project to make sure that cases are dealt with expeditiously in the courts and that backlogs are indeed eradicated, or if not eradicated, but at least that something is done about the backlog. So yes, it's a lot of hard work, because as you know, as a JP, one is not only in a managerial capacity there, but you're also operational, because you lead from the front as a JP. When there are difficult cases, intricate cases, you sit in court yourself and do those cases.
So basically, you have been exposed to all the functions of a judge president.
Definitely.
And is it correct that you are currently also serving as a member of the Performance Monitoring Committee for the division?
Yes, as well as the Infrastructure Committee.
That's right. And in the former capacity, you are directly involved in the case management of cases in the division.
That is correct, JP.
Thank you, CJ.
Thank you, JP. Premier? Thank you, Premier. Any other Commissioner? Commissioner Singh?
Thank you very much, Chief Justice. No, I think Commissioner Malema says, but this question is going to help all of us seated on this side of the room. Okay. Honorable Judge, I note that you are chairperson of the commission that deals with the remuneration of public office bearers.
Well, that is correct, Commissioner.
And that includes all of us here. I think we all wait for your announcement and your pronouncement.
Except for the people representing the attorney's profession, the advocate's profession, and the academia. Yeah. But otherwise, everyone else,
yeah.
The rest, yeah.
So they better behave themselves.
Yeah. Well, I've already made my recommendation.
Yeah, no, Chief Justice, one of our criticisms as members of Parliament, and I think it affects yours as well, is the long delays it takes to pronounce or make recommendations. So much so that sometimes we get our increases 10 months retrospective. We get it, but it does take time. And I understand this year is going to be the year when you're looking at members of parliament. Last year you looked at local government. How is your position, if recommended, going to impact on your time to deal with this particular responsibility?
Commissioner Singh, firstly, the review relating to the legislature and the executive, that has been approved by the presidency. There is a budget for it. We have already appointed a service provider to do the necessary research, because we have a new way of thinking about the salaries issue. Instead of having one review for all public office bearers, we decided maybe the most serene thing to do is to eat the elephant in chunks. So there was a review for local government that has now been completed. We are moving over to the legislature and the executive, and hopefully during the second part of next year we will deal with the judiciary. In respect of the delays, you would be aware of the fact that it is a very sensitive issue. The strike season in South Africa normally ends around September, and it would be unwise for His Excellency the President to make a pronouncement on the salaries of judges, members of parliament, members of the provincial legislature, whilst there is still blood on the floor in respect of strikes relating to the public service and other people who are not part of the public office bearers. So the presidency normally, as a general rule, wait for those processes to play themselves out thoroughly and completely before making a pronouncement on the salaries of judges, MPs, traditional leaders, kings, queens, and members of the provincial legislatures.
Thank you, Judge. I think Honorable Didiza will be very keen to interact because she represents our interests on this particular score as chairman of the House. Your master's, what was the thesis? What topic did you write on? Was it
I dealt with workplace forums. It was in labor law. It was just when the workplace forums were introduced in South Africa.
And the very last question is, I noticed a case here in Lesotho, the Attorney General versus His Majesty the King.
Yes.
Now, anywhere else one would shiver when you say versus His Majesty the King, especially in KwaZulu-Natal. So can you just give us some idea of that case? And
yes, the matter related to the appointment of the President of the Court of Appeal of Lesotho. What happened is there were cases against the President of the Court of Appeal, who was also the Chief Justice of Swaziland then, Mr. Ramodibedi. What then transpired is His Majesty the King decided to have a tribunal to investigate President Ramodibedi's fitness to hold that office. He then resigned. The Prime Minister then advised the King to appoint somebody, Mr. Musi, who was not a permanent judge. He was an acting judge of the High Court and also the acting judge of the Labour Appeal Court with me at the time. So when that happened, some legal practitioners, including the Attorney General, were dissatisfied with the manner in which this appointment happened. They then, because it's the King that makes the appointment on the advice of the Prime Minister, they then had to take the King to court. And the King defended the matter, and unfortunately for the Attorney General, we found against him, in that we found that the King had the power to do so, and that the Prime Minister had the power to make that recommendation to the King. The matter was taken on appeal, and he was unsuccessful on appeal too.
thank you, CJ.
Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Musi.
Afternoon, Commissioner.
It's only one question from my side. What are your primary strengths as an administrator?
Well, firstly, you will note from my CV that I have the theoretical qualification. I have an honours degree in public administration, which is now called public management. Public administration, a degree in public administration for the civil service purposes was the degree in terms of management. You will also note from my CV that in my time as a prosecutor, I was also the control prosecutor at Magistrates Court Mitchell's Plain and managed prosecutors resorting under me. I have been in management of organizations, as the JP just pointed out earlier, and I've also managed the High Court in my capacity as the acting JP.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Didiza.
Thank you very much, CJ. Honorable Singh has already made a declaration on my behalf that I do know Judge Musi, and I have to interact with him on the issues of remuneration of public office bearers, which relates to all of you. But fortunately, this matter has nothing to do about remuneration of anybody else, so I don't think it would come on the way of the discussion. One of the things that I would like to ask, given where we are in the judiciary, that while we have noted improvement in terms of gender representativity in the various courts, what is it that you think would need to be done to ensure that we attract, retain, more women in the judiciary?
Yes, thank you, Commissioner. I don't think that there is a one-size-fits-all approach, but one must have a multi-pronged approach. Firstly, one must make the judiciary more attractive for practitioners generally, and specifically then for females. Secondly, training. One can have training courses like we had in the past under the auspices of the Honourable Minister. Some of the ladies that went to their training actually came onto the bench, and they did a splendid job. I think my JP is one of the products of such training course. We have at our division another judge, Judge Naidu, and in the Northwest as well as in Gauteng, people who benefited from the training because they were identified as people who could be trained, but because they have the necessary potential. The other thing that we should do is probably to think out of the box and not only focus on practitioners, but also go to the academia. There are many female professors and senior lecturers there, which we could also target, give them the necessary training for them to be appointed on the bench.
Given that gender is a social construct in one way or the other, would you not think it would be necessary that this kind of training should not only be for women, but also for male judges?
Well, you're talking about post-appointment. I'm talking about training because you're targeting women in order to make coming to the bench more attractive. Training them post-appointment is for all judges. That happens. I'm part of their training. In fact, during January this year, I trained judges on cybercrime. It was mixed judges, male and female. But if one wants to attract specifically females, more female judges, we must also remember that the briefing patterns for practitioners are somewhat skewed. So one must therefore target black people generally, target females for appointment to the bench. And the manner in which you do it is really to say, well, there are prospects of being appointed to the bench. We do not have the necessary pool. So you create a pool by having people trained, having them act, they go into the pool, those who want to apply when they are ready, and so forth. But training post-appointment for all judges. In fact, under the Judicial Training Institute currently, they have training courses for all aspirant judges, if I may call it like that.
Which does have a gender module, I hope. If not, hope it will be next time, so that it becomes natural for all of us, so that it does not continue being just an issue that we deal with it when we are faced with a challenge. Your contribution to law, in terms of the publications that I've seen, there is one that relates to maintenance and culture.
Yes, and ethics as well.
And ethics. Just a little bit. If you can say just a little bit on that one, what does it seek to address? Or what did it seek to address at the time?
Well, what it sought to address, Commissioner, was to change the attitude and mindset of magistrates, especially then here in the Western Cape, because I was then attached to the University of Cape Town's Law, Race and Gender Unit. But what we found was that a magistrate would, for an example, on a particular day, have 10 maintenance files. What would happen is they would go out and call the names of the parties. Now, if the complainant is not there, who is under normal circumstances a woman, that matter would be struck off the roll. And they would continue dealing with the other matters. But the tragedy was that if that woman comes to court and half an hour later, she is told, well, your matter has been struck off the roll. What you must do now is you must go and lay a new complaint, and then you'll get a date 6 months hence. And to us, it was totally unacceptable. And we said, well, let's change the way in which we work. Start with those that are ready. If you call out the parties and there are 2 parties that are there, start with that case. Because there are so many variables for women not to be at court. This woman's child got ill that morning, and she had to rush to the clinic or to the doctor, and therefore she comes late. But because she comes late, she's now punished by not having a child maintained for another 6 months. And those were the issues that we basically concentrated on.
Thank you very much, CJ.
Thank you, Commissioner. Just to clear up something, you know the aspirant judges program runs.
Yes.
How differently should it run so as to address the gender factor?
Well, CJ, as it is now, it is open for all who wants to become judges. But you will remember there was a project, I think it was Minister Mabandla, where they targeted females. And they said, well, we have a paucity of female judges, and the time has come to transform the bench in terms of gender. Therefore, this project will only be for aspirant judges who are female. It was a very intensive course. And from that course, I must say, many judges were appointed thereafter.
You would recall the reason why even those who were advocates and attorneys made themselves available was that the Canadian government made it possible for them to be paid at least 19,000 rands per month. How do we handle it when the minister is just indicated that there will be more cuts, or can you come up with something?
Well, CJ, firstly, if we are serious about transformation, and
no, since we are serious about it.
Since we are, all right, I think the money aspect should not be the primary focus. We should make money available for it. If it would and help, money should be made available. There can be synergies between the Department of Justice, the Judicial Training Institute, and even the Office of the CJ. To see
economy or no economy?
No, CJ, I do not think in the greater scheme of things that that kind of money would make such a dent to our economy. Because if one looks at it, at the economies of scale, we're talking about 19,000 rands a month for 20 people plus minus. So what bigger dent can that make if one looks at the greater good that that money would serve?
Because of your position as chair of that important committee, the next time I have the meeting with the minister to have the budget increase so that these practitioners could be accommodated, you must be there.
Chief Justice, you'll be glad to know that the minister actually said, we in any case sometimes operate on a deficit, and if money has to be found for a good cause, it must be found. So yeah, I agree with him there.
Thank you for saying it in his presence. Thank you for saying it in his presence.
For
and
the
publicly.
record, I'm being misquoted.
Thank you, Chief Justice. Good afternoon, Judge Musi.
Good afternoon, Commissioner.
In one of your questions in the form, on your contribution to law, you made reference to the transformation of the magistrates. So, how is your experience from the magistrates will contribute to the advancement of change in the division, considering the fact that Bloemfontein and where your court is situated, there are so many of the racist issues that emanate from that community?
Yes, thank you, Commissioner. Commissioner, by and large, at the court itself, we do not have a big problem with racism because we are in the majority in any event. We currently have a component of 12 judges, 4 of which are white, that is male and female. The 8 are African. Of the 4 whites, 3 have less than 5 years experience. The average experience of that court is 7.2 years. So in terms of experience, leadership, our leader is the black female, by far, we don't allow in any case racism to raise its head. Now, during February this year, I had occasion to interact with some of the colleagues. In fact, there was one colleague when we spoke about some cohesion, social cohesion at the court, which would also mean that we must go out sometimes just for lunch as a group of judges. And this particular judge said, well, my interaction at tea time with the judges of this court, did not mention race, I must say in his favor, is sufficient. And I just couldn't let that lie at that level. I then took him head on and explained to him what social cohesion means, not only on the level of the human beings, but for the organization as well. Thank you.
Just 2 quick ones. Judges are to enjoy independence, but they must also be accountable. Do you agree?
I agree fully.
But you would also know that when you seek accountability in the form of ensuring that you're able to keep track of reserved judgments, part-head matters, some colleagues complain that you're monitoring them either on behalf of the executive or on behalf of parliament. They are judges, they are not supposed to be accounting in that fashion. What is your view on that?
CJ, my view is clear on this. You cannot have rights without responsibilities. You cannot have unfettered independence, because with independence comes accountability, as you correctly say. Now, judges normally account by giving their judgments and in their judgments. But the problem is, what is the system to do when a litigant comes to court hoping that his or her dispute would be adjudicated and determined as quickly as possible. But the judge then delays the judgment. The judgment is outstanding for 12 months, the judgment is outstanding for 6 months. One cannot then say, well, because the judge is independent, there should not be accountability. I think the accountability should come from the judiciary. It must be designed by the judiciary in consultation with the judiciary, and the norms and standards as they currently are is such a product.
And the last one very quickly. You know that attempts have been made to discipline those who have taken too long to deliver judgments, those who have one alleged misconduct or the other. And the perception is these judges are simply failing to deal with shortcomings within their ranks. What is it that can be done to dismiss the possible perception out there that judges can act with impunity, they can do wrongs with impunity, prejudice the public as they like, nothing will ever happen to them? And why should the public not think that that is in fact the position?
CJ, firstly, the very purpose of a code of ethics is to make sure that there is accountability. The existence of the norms and standards is to ensure that there's accountability. So when we talk about perceptions out there, one, I think endogenously as the judiciary, we should probably make known that judges are indeed governed by a code of conduct, that judges do not act with impunity. And should a judge fall foul of our norms and our standards and our rules, our ethics, judges will be dealt with. And that is why there is a Judicial Conduct Committee.
Well, the point is this. They have been reported, nothing has happened. That's the point. What is your answer? What could be done?
Well, if they are reported, there is a body, the Judicial Complaints Committee, that must do their job. At some stage, action must be taken against the judges. Not all transgressions will necessarily lead to impeachment, but within the JCC, there must be some remedial action taken against those judges, and maybe we should publicize those for the public then to see that we are dealing with judges who are deviant and who transgress certain norms and standards.
Thank you very much, Judge Musi. You're excused.
Thank you, CJ. Thank you.